Hi, everyone. This is Sam Silverman with EB5 Affiliate Network. Thank you for taking time to join us on today's webinar. Today, we've got a couple exciting topics to cover. We're going to chat about the recent USCIS lawsuit settlement that just got proposed last night. And we're going to chat also about why EB5 investors now have a greater chance of success, both from an immigration and from a financial safety perspective under projects that are now subject to the new USCIS rules that just went into effect a couple of months ago. During the webinar, if you have any questions, please use the chat box on the screen and we'll try and cover as many questions as we can during the webinar. A video recording of this will be available as well. So just by registering, you'll get a link in a couple of hours with a link to the recording if you want to watch part of it and go over. And we can also make the slides available as well. So if you'd like to get a copy, a PDF copy of the PowerPoint, please send us an email at info@eb5an.com and we'll be happy to send over the slides. Okay, disclaimer, this presentation is not legal advice and is for informational purposes only. You should engage your own legal counsel for legal advice before making any investment and legal decisions. Skip over that. So fortuitously, we had a webinar scheduled today with Ron, and with this recent settlement that just became public a few hours ago, we're very glad that we had that on the books already. And so Ron has been an integral part of the negotiations of this deal that are now public. And so we're excited to have him with us today. Ron's a legend in the EB5 space and the immigration community. And yeah, without further adu, I'll let him jump in and share a little bit about his background, and then we'll jump into the topics for today's webinar.
Thank you, Sam. So in addition to what you see on the screen, I guess I should mention two things. One is that I chair the EB5 practice at our law firm, which is one of the largest EB5 practices in the country. We're a law firm of about 115 people just doing U.S. immigration, and a lot of that is EB5. We deal with all aspects of EB5, representing investors, projects, developers, compliance. And the other thing I should mention that's very relevant to today is I have chaired for the last 3 years the what's called the High Impact Litigation Committee of the American Immigration Lawyers Association. And as Sam said, I've been involved in about as high impact litigation as you can be involved in over the last couple of months that resulted in a settlement with USCIS to take this regional center EB5 program, which has been somewhat between dormant and stagnant, and now have it go full speed ahead. We're going to talk about the results of the litigation, which were just filed with the court last night. So this is first program on the block about that. Lots of things that are important to talk about, but the main message is that the regional center EB5 program is finally full speed ahead as a result of that settlement.
Perfect. Thank you, Ron. And yeah, as Ron said, there are some things that are very clear, but there's still, as always, in EB5, many things that are still somewhat unclear. And so we're going to cover kind of the high level items in both of those categories today. As I mentioned earlier, I'm Sam Silverman. My bio is there on the left-hand side. My partner, Mike Schoenfeld, is also on the line, but I think he's in transit at the moment, so he may not be able to chime in here. So we'll skip ahead. So quick little bit about EB5 Affiliate Network, or EB5AN for short. We're a national leading EB5 investment fund manager. We sponsor projects with over 2,000 investors from more than 60 countries. We've been working with Ron since 2013, 2014 on different projects. This is a quick map showing where many of our investors have come from over the years. And now jumping into the main event here, Ron, tell us kind of the high level summary of what's been happening the last couple of months, and how did give us the context for how did we get to the settlement agreement last night, and what does that kind of immediately mean for regional senators and investors, for the things that we do know, and then we can shift over to things that are still unclear.
Sure, Sam. Very, very happy to do this. So, a brief history. We know that the what we call the RIA, the EB-5 Reform and Integrity Act, was signed into law in March of 2022 with an effective date of May of 2022. Everybody celebrated. We now have a regional center program moving forward. Unfortunately, USCIS posted a notice on their website unilaterally deciding that every single one of the 630 plus regional centers has lost their designation and has to reapply for a new designation, which would probably take many years before that would happen and the program would start. A number of different regional centers. We represented 5 of the major regional centers, plus we represented IIUSA, the regional center trade group, and we, as well as another regional center, filed a lawsuit to enjoin the Immigration Service from decertifying all the regional centers. Our litigation was successful, and we achieved a nationwide preliminary injunction against USCIS, and saying that they cannot decertify the regional centers. All the regional centers that were designated before are still designated. Well, that what we thought was cause for celebration, but it turned out that the USCIS had something else that would prevent the program going forward. They issued a new form called an I-526E for investors, and they stated that you can't file the form until you have a receipt notice for the project application, which is called the I-956F. Well, that's wonderful, but there's only one catch, and the catch is that they weren't issuing receipt notices. And so these I-956Fs were pending for months with no receipt notices, which prevented the investors from filing the petitions. Finally, as of late last night, we reached an agreement, signed, sealed, delivered with the USCIS, filed with the court last night, that will take care of all those problems and have the program move forward. One of the things it makes clear is that if there is no receipt notice issued by USCIS within 10 days, then investors can still submit the I-526E and use other proof of filing, and that's a really important part to get this thing moving. I should mention that the settlement agreement is technically not final. It's legally not final until it's signed off on and approved by the judge. And we have no reason to believe that Judge Chabria will have a problem with this. We hope that we will get an actual approval from the court, maybe even today, but technically it's not final until approved by the court. So some of the other things that are critical in the settlement. So regional centers have until December 29 of 2022 to file amendments to continue their regional center authorization. The regional centers are in business as of now. They continue in business until December 29th. And assuming they file on December 29th, they continue in business after that. There is no requirement of the approval of the I-956 in order for regional centers to sponsor projects and investors. Regional centers that choose not to file a 956 will not be able to sponsor new projects or investors, but grandfathered investors in those regional centers will still be able to be approved even if the regional center chooses not to continue to do business under the Reform and Integrity Act. We're hoping to get a more efficient system. The settlement agreement has language that says USCIS will undertake best efforts to provide the receipt notices by express courier so that we don't have to wait for the 10 days. but that's not a certainty at this point. I hope it will happen. We have a lot of good language in the settlement agreement that says that the USCIS will give deference to previous regional center approvals, and that USCIS will give deference to previous project exemplar approvals. So for example, if a project already had an exemplar approval under the old law and wants to continue to accept investors under the new law, they will have to file an I-956F, but at I-956F, there'll be deference given to the fact that the project was previously approved. Some of the other key issues is that the government will be revising its forms. There are a lot of problems with the forms that were created. And there will be, the government has agreed to a notice and comment rulemaking for the new forms. And so the public will be given an opportunity to make suggestions on all of the new I-956, 956F, I-526E forms before new ones become available later in the year. One of the very important things that we were able to get added on is a provision that the USCIS agrees that for the next 2 years, it will have quarterly meetings with representatives of the plaintiffs to talk about the settlement agreement, the implementation of the settlement agreement, and any modifications that are needed to make this program successful. So we're very happy that we will have continuing dialogue, which many of you know is unusual in this field, in connection with the implementation of the EB-5 program. I guess the last thing I'll just mention is the 5 regional centers that we represented, and that really, I think, did a major service to the EB-5 industry by agreeing to be plaintiffs in this litigation are EB-5 Capital, Can-Am Enterprises, Civitas Capital Management, Golden Gate Global, and Pine State Regional Center. The other regional center that we didn't represent is the Bering Regional Center. And it's through the efforts of all of those regional centers willing to be plaintiffs that we now have what looks to be a very functioning EB-5 program ahead of us.
Great. Thank you, Ron. Could you just spend 1 minute talking about the receipt notice situation and how that's going to work mechanically for projects now going forward that don't have to wait for the notice in the mail?
Sure, that's real important, Sam. So under the law, upon the filing of an I-526F, an investor can proceed to file the I-526E. Well, then the question is, how do you prove the filing of the I-956F? So one way is if you get a receipt notice. So if you get that, you're good to go. The second way is if you get a lockbox notice. The checks are submitted to a lockbox. If you get a lockbox notice, you're good to go. Well, when we were negotiating the settlement, the issue is, well, who knows? Maybe, hopefully they'll be efficient and they'll get us lockbox notices within a day or two, or receipt notices within a few days, and that's lovely. But we had to deal with a what if, and because we have been months now without receipt notices. And so the what if is, well, what if you don't get us receipt notices or lockbox notices as quickly as you think you will? And that's where we got agreement to a 10-day maximum. If for whatever reason the Immigration Service does not issue receipt notice or lockbox notice within 10 days, 10 calendar days, then upon the investors can file the I-526E petition, and the regional center will provide proof of the filing of the 956F at least 10 days ago, and proof of, presumably there'll be a canceled check. There'll be the first 6 pages of the I-956F, but this is we hope that we won't have to wait 10 days, but if the Immigration Service is delayed, we won't wait more than 10 days.
Got it. Okay, that makes sense. And one of the aspects of this new required filing for Form 956 is the potential to expand geographic coverage. Could you talk a little bit about that? Because now that everyone who wants to keep doing new projects post December is going to have to file this and pay $18,000 no matter what. And so, to kind of get more bang for their buck, what could they do in addition to, filing the minimum compliance, components of the form?
Right. So we did address this in the settlement agreement. And the settlement agreement says if a regional center is filing the I-956 at the same and basically saying we're continuing the regional center that you designated under the old law. As part of that, they can also say, and by the way, we want to expand our geographical area. Well, if that happens, the Immigration Service will continue to give deference to the previous approval. But the fact that you're requesting an expanded geographic area doesn't mean you no longer get deference to your previous approval. However, the geographic area expansion is not effective until approved by the Immigration Service. So in that case, the regional center can continue to sponsor projects in the originally approved geographic area, but they can't sponsor projects in the new geographic area until that is approved.
Got it. Okay, so no 50-state land grab while pending approval.
No, and there's certainly no indication in the new law, in the RIA, that the Immigration Service will likely be more expansive in its view of regional center geographies. We don't know that, but there's nothing that I see in the RIA that leads me to believe that the Immigration Service is going to start saying that you can have much wider geographic areas. And in fact, the RIA does have some language making it clear that regional centers have to be focused on specific regions, specific areas, and not just many states in one regional center. Got
it. Okay, perfect. Okay, so let's shift over and kind of talk about the second topic of today's presentation, which is why EB5, now that it's fully open as a result of last night's settlement, why is it safer for EB5 investors? And to kind of lead into that topic, let's first quickly cover the Reform and Integrity Act, and then we'll kind of apply those provisions to how they impact new investors going forward.
Okay, so the Reform and Integrity Act, most of you listening know that this is the first long-term extension of this program in many, many years. So we're in better shape than we've been for a very long time. The investment amount is $800,000 in a TEA, $1,050,000 otherwise. There are new rules for TEAs, and the TEA definitions are more restrictive. The states are no longer involved in the TEA process. It now has to be approved by USCIS as part of the I-956F filing. Now, there's a new concept which is very important, and we're all going to have to see together exactly how important. But there's a new concept called set-asides, and 20% of all of the EB5 visas are set aside for rural area projects. Now, this is extremely important, especially for our Chinese clients, because even though our Chinese clients remain mired in a wait that may be 10 or 15 years under their previously filed EB5 petitions, the rural area set-aside is a brand new category with nobody in it. There's no waiting list. And that means that if a Chinese, certainly the way we view it, and I think the way the State Department agrees, is if a Chinese investor invests today in a rural project, they are first in line and not, backlogged for 15 years. So that creates new opportunities for Chinese investors. It affects to some extent Vietnamese investors, and there may be backlogs at some point for Indian investors. So this could be important. There's also a 10% set aside for high unemployment projects. The high unemployment set-asides will probably be used up a lot quicker than the rural area set-aside, simply because there are a lot more high unemployment projects than there are rural projects. A very important provision in the new law, for the first time, allows EB-5 investors who are in the US to apply for their green card, what's called their adjustment of status, at the same time, concurrently, with filing the EB-5 petition. So this does a number of things. Number one is it saves a ton of time. If, let's just say it takes 2 years to get an EB-5 petition approved, and only then can you start the green card process, and that may be another year. If you're doing it all together, then you may save easy a year or so in the whole process. And secondly, within a number of months, and it's very difficult to predict, but let's say possibly within 6 months or so, by doing this adjustment of status, you should be able to get an employment authorization document. One of the key things is that if you file for adjustment of status and you're not in H-1B or L-1 status, then you can't travel while that's pending until you get a travel document, which can take many months to obtain. So the key takeaway on this adjustment of status is it's a wonderful opportunity for a lot of people, not necessarily the best answer for everybody, and you should definitely talk to your attorney as to whether it's the right option for you.
Got it. But if you're already in the US on one of those categories, this is a way to just stay in the US. And yes, there are some restrictions around travel and employment. You'll have to wait for the EAD approval, but it makes it so they, you can't be kicked out and you can remain until you actually get the green card.
Yeah.
All right, so moving over to the next couple.
Yeah, so some of this we can run through pretty quickly. The key things on this slide is we used to have what we call pooled direct projects, and pooled direct projects mean a direct application is without a regional center, where an investor is investing in a business, the investor is going to own some percentage of the business, and the business will create 10 full-time W-2 employees. And it used to be we had pooled direct investments, so we might have 10 investors in one business that was going to create 100 jobs. Can't do that anymore. The RIA says a direct must be limited to one investor, otherwise it's got to be a regional center application. There's lots in this new law, some of which we'll talk about, requiring high levels of compliance by regional centers. From a regional center point of view, there's lots more liabilities, lots more responsibilities, lots more compliance, much more costly, and the end result is it may be that not every regional center will want to continue to stay in business, but the ones that will have, which is really good news for investors, will have very, very high levels of compliance responsibility, financial compliance, securities compliance, and that should give investors some assurance. The redeployment is the concept of when your money has been used in the way it was expected to be used and the jobs have been created, but you're not able to get your money back yet because you haven't completed what's called the sustainment period, then the regional center has to do what's called redeploying your money to another project. And the good news on this is the RIA provides much more flexibility on where the regional centers can redeploy the money. And this was a problem for investors before, because if there were very few redeployment opportunities and the money wasn't redeployed properly, the investors could lose out. The innocent investor protection, it's what's called good faith investors in the RIA. And the concept here, and honestly, this is not as broad and helpful as we hoped it to be, but what it says is that if a regional center is terminated, or the NCE or JCE, the investment enterprise or the job creating enterprise is terminated, it used to be that investors were out of luck and basically had to start all over again. Now they will have up to about 6 months to find another regional center to sponsor the project. It can be in a different geographical area. And if the investors do that, then they will not lose their place in line and will not lose out. The offshore agents issue is a very big issue, but something we can't talk too much about yet, because the Immigration Service has not yet come up with their forms, their rules, their policies, or anything. But basically, the concept here is that anybody involved in the marketing of an EB-5 project has to be registered with the USCIS. And again, we don't know what their rules are going to be or the forms or anything else, that they'll have to meet strict requirements, and there has to be complete transparency, including disclosure of all fees paid by everybody in the process that must be available to the investors.
Got it. Okay. And we can really quickly touch on these.
Yeah, so well, the source of funds, they're not very substantial changes in the source of funds. So you do need 7 years of tax returns. That's a little bit more than before, but the changes there are not substantial. The last two things on the slide are substantial. So for the first time ever in immigration, if you have a denial of an application of an I-526E or an I-29, well, not an I-29, of a 956 or 956F, you can't just go to federal court. You must first go to the Administrative Appeals Office before you can go into federal court. That does not affect mandamus cases, so we file lots of mandamus cases. That you can still do. It's just if there's denials, you have to do what's called exhausting administrative remedies. And the last thing on the slide is that if there are delays in job creation, so I think everyone listening knows that from the time you get your conditional green card, you have 2 years to file the I-829 condition removal petition and prove the job creation. Well, what happens if all the jobs haven't been created yet? There's been delays in the project for whatever reason. The new law for the first time provides another year where you can get permission to delay the filing of the 829 for the third year, and hopefully by then the jobs will have been created. So that's a benefit to investors also.
Perfect. Okay, great. Now we're going to shift gears and kind of talk specifically about what some of these policy changes really mean for investors and how new investors are really advantaged compared to investors who were coming in, prior, 2019, 2020, prior to the lapse. Yeah,
so a lot of things here are really good news for investors. So, first of all, the fact that the program is authorized long-term is good. There's a provision that says that as long as you have filed by September 30, 2027, even if there's a delay in reauthorizing, you're grandfathered. That's good. The investment amounts are fixed. A lot of us, these numbers are less than the original regulation that was passed by USCIS back in, December of 2019, I think. And so most people can live with those investment amounts. So all of that is good. Going to the next slide, the TEA changes are not exactly what people wanted, but they are valid for 2 years. So you do know whether you're in a TEA or not once there's a determination. I think we can go to the next slide. We talked about this concept of set-asides, and I talked about why it's very important, especially for people from China. Also, rural projects, in addition to being eligible for this new set-aside category, under the RIA, rural projects are required to be processed quicker than other projects. It's a new concept called priority processing. This is not an expedite. So an expedite means that the Immigration Service has decided that these cases, that, you know, because it's in the national interest, certain cases should go before any others. That's very case by case. But this is saying every single rural project should get priority processing, meaning that they should be quicker. That doesn't necessarily mean 1 month or 6 months or 9 months. It just means quicker than other petitions are processed. So that is a good news. So from the investor's point of view, things are full speed ahead really for the first time now. So, you know, we've known since the new law passed that you need you can only invest, as an investor, you can only invest in a project that has filed an I-956F. So one of the first things you've got to check with a potential regional center or project is, have you filed the I-956F? Now we know that there's, you know, at most a 10-day wait after filing the I-956F before somebody can file an EB-5 petition. The EB-5 petition gets filed does not have to contain all of the information that it used to. So in every one, if we had a 100 investor project, every one of the 100 investors had to file the thousands of pages explaining the project. Now that's only filed once with the I-956Fs, and the investor only needs to file things about the investor, most specifically the source of funds, and not have to file everything that's in the I-956F, so that's a benefit.
Got it. Redeployment.
Yeah, so I mentioned before redeployment, and I think Sam, I've covered the concept of redeployment. The big change here is that under the old law, the Immigration Service took the position that the redeployment of the capital must be in the geography of the regional center. And many regional centers that have pretty small geography, there were really no good projects to redeploy in that geography. And now this is expanded and there's a lot more flexibility, and that also is good for investors.
Perfect. And then we'll spend a minute too on innocent investors and how I know you mentioned, Ron, that this isn't exactly what everyone was hoping for, but how does it help?
Yeah, so it doesn't, what we really wanted is something to deal with investors who were defrauded. And, you know, most EB-5 projects have proven to be good job-creating projects. Many people have gotten their money back and their green cards, but there's been some fraud for sure in the EB-5 program. And what we were hoping as we worked with the legislators is that they would come up with some language that would say, if you are a completely innocent investor and you've been defrauded, you know, we're giving you relief. Well, that's not in here. Or what if you're a good faith investor, you did everything you're supposed to do, but for whatever reason, the project never got off the ground, and you've lost your money. Well, there's no real protection for that. What there is protection for is only if the Immigration Service actually terminates, which is a pretty formal, long process, actually terminates a regional center, or does what they call debar the NCE or JCE, only then can an investor get some relief by having the project associate with a different regional center. So it's limited relief. It helps especially people who are investors in projects in terminated regional centers.
Got it. Okay.
And we have talked about the fact that you have an extra year to prove up your job creation for the 829.
Right, which gives investors more flexibility if the jobs aren't all in place in that 2-year period, which is also, you know, really favorable.
Right.
Perfect. Okay, so we're now going to switch gears and chat a little bit about two projects. One of them is one we're currently working with Ron on, and then we'll open it up for a few questions. Ron has about 30 minutes left, so we'll fly through these project slides and then leave a few minutes for questions at the end. Okay, so the first project we're going to quickly chat about is called Walhalla Utah. This is a rural EB5 project available now at $800,000. We filed the 956F more than 10 days ago. So if the settlement gets approved, investors will be able to immediately file for this project. Okay, so a little bit about Walhalla, Utah. It's a rural project located just north of Park City. It follows 14 prior EB5AN regional center projects located around the country, all of which have been successfully approved by the USCIS. Okay, some specific details about the project. This is a project that is a single family, single residence community being developed around 2 golf courses and other upscale amenities. It's just north of Park City, Utah, which is a major travel tourism 4-season vacation destination, golf in the summer, skiing in the winter. It's a residential community, single family homes being developed around amenities. EB5 for this project is structured as a secured loan, 99 investors, $79.2 million total, just less than 20% of the total development cost. As we talked about earlier, as a rural TEA, it provides priority processing, so faster I-5260 approval, and 20% of the visas set aside, which can be very valuable for Chinese, Vietnamese, and potentially Indian investors as well. The project has an I-5260 approval refund guarantee. If an investor is not approved, they get their funds back earlier, and job creation guarantee as well. There's already a $50 million senior construction loan in place that's funded. This project is structured with a rolling 5-year loan term, which means that the duration of the investor's capital in the project is exactly 5 years from the day the $800,000 goes in, with a 1-year optional extension. So unlike many EB5 projects with different requirements for the start and end of the loan and approvals, etc., this is super simple. Once your 800 goes in, that's the day your 5-year period starts and potentially extendable by just 1 year. Phase 1's nearly sold out. Construction's been underway for almost 2 years. Golf course is almost done. There's already more than 300 EB5 jobs in place. And this is a project where we've structured the project to accommodate partial investment filings, meaning that if you're interested in getting started and filing your application, let's say you're on H-1B or L-1, you're in the US, your visa is expiring in 6 months, and you want to stay, you can do a partial investment today, invest less than $800,000, put some money in now, start the process, adjust your status immediately, and then fund the balance of the $800,000 due within 12 months. That's available for people in the US and outside the US, but really particularly impactful for those who have a limited duration on their current visa. And so we have that flexibility with this project. Ron, on that comment, I know you're familiar with the concept of being in the process of investing, but could you kind of describe how the EB5 rules specifically allow for that? But then, what are some of the things investors need to be careful of and aware of, and how that has been accommodated in the new 5260 form requirements?
Yeah, I think when we're dealing with people who are not doing the full investment up front, the key is to still do complete source of funds on the full investment. So what I mean by that is it's not okay to say, well, I'm investing part of the money now, and I hope eventually I'll sell my house and maybe I'll have more money in the future. You have to show that you have the full amount available now, but for whatever reason, you're not investing all of it now. That concept of actively in the process of investing, USCIS generally accepts.
Got it. So clear path, clear documents showing where the balance is going to come from at the beginning. And that makes sense.
Yeah,
Okay.
I must say, Sam, I always feel more comfortable, and I advise my clients that investing the full amount is the safest way to go. Anytime you're doing something that is not like what the Immigration Service usually sees, you're giving them more opportunity to issue some decision that may not be correct.
Exactly. And yeah, I think that's important to realize in the context of these set-asides, right? We're now looking at 10% set aside for high unemployment, 20% for rural. And so, you know, other than being able to adjust immediately with a partial filing and get the immigration benefit today, if you were already in the U.S. in one of those visa categories, would be to potentially make sure that you're, you know, one of the first people in line if you're, you know, from India, Vietnam, China, and you're concerned about potentially, you know, there not being a visa available for you later. By getting in line earlier, you know, you're really trying to mitigate that risk of first in, first out, generally trying to be one of the earlier people approved. So that would be kind of another angle depending on, and again, this is very case by case, and you need to discuss the options and weigh the pros and cons with your own immigration counsel. But those are some of the things that we hear from our clients as they're, you know, considering what project and whether to do a partial filing or put the entire amount in if that's an option. We'll cover now just a quick few images of the project. This is a rendering of the central village area where a lot of the homes are going to be centralized around the amenities, golf course, and backcountry area. Recent golf course construction photo. Golf course should be done later this year, early next year. This is one of the golf course practice cabins. Couple images of the backcountry area, on-site sales, golf area as well. And I'm sure many of you are familiar with Park City, Utah. It's a globally recognized destination. Sundance Film Festival's there, Olympic ski team, major vacation destination. It's one of the few destinations like this that's 4 seasons. So you have a lot of people coming in the summer for golf and biking, the winter for all the winter sports. This is a map showing the location of the Walhalla project and number of very high-end resorts and ski facilities within a short drive. Okay, this is the important part, the way the loan is structured. So as we talked about earlier, EB5 funds go into the project. Once all $800,000 is invested, loan term starts, and then there's a 1-year optional extension at the end of that 5-year term. This means that each investor, assuming every investor funds on a different day, the repayment of the project is going to be staggered. So instead of having to rely on a single giant refinancing event or liquidity event where all 79 million gets paid on a single day, this allows for the repayment of tranches individually in $800,000 chunks as the loan matures. So much more flexible, clearer term for investors. So you've got greater visibility on exactly how long the money is going to be in. And it also gives the developer more flexibility as they're building and selling homes. This rolling off of capital instead of a one-time bullet repayment, it fits the development style of this project, which is building and selling homes over an extended period of time. This is a quick map showing the 2 different major parcels of land that comprise the Walhalla development. One is the backcountry, which is kind of like a large 3,000 plus acre private park for Walhalla residents, hiking, skiing, backcountry, all of that. And then the development parcel where all of the money is being spent, golf course, amenities, clubhouse, all of that. And the security of the loan for this project is a first mortgage on the entire backcountry and a second mortgage on the development land, along with an equity pledge from the development company. So directly secured by mortgages on development land. Another kind of unique feature that we've built into this project is an ongoing quarterly loan to value collateral test. This gives investors confidence that we're checking the value of the collateral, representing the total amount owed under the EB5 loan every 3 months with independent values. So we look at the total value of all assets in the project that our loan touches, minus the senior debt, which is ahead of EB5 just on the one piece of the project. That gives us the effective collateral for EB5, what's left, and then our loan cannot exceed 150% of that. So we always have a very large margin of safety that's evaluated independently by EB5AN on a quarterly basis to make sure that when the loan tranches, each of 800,000 come due, there's more than enough collateral there to satisfy the collateral repayment obligations as the loan matures. And most importantly, big picture, whenever an investor is evaluating and whenever we're evaluating a project, we're always focused on immigration and financial safety. So on the immigration side, we want to see something that's fully capitalized with loan already funded from a national lender, $50 million already funded in place, lots of jobs, 44 jobs per investor, 300 plus jobs already created, and a guarantee from the developer that they'll create at least 10 jobs for every single investor. And then of course, on the financial side, we're looking for a secured loan investment. Clearer term is better. In this case, very clear 5-year term, strong sales to date, 526 approval refund, ongoing LTV test, and then just big picture, because this project follows the same style of project that has been done in this area over the last 25 years. There are a number of other single family golf communities in the immediate area that have been successful over the last 20 years and have sold out. We can see exactly how many homes they've sold and look at the assumptions for the Walhalla project and get comfortable that there's been enough sales at the similar prices over time that this project shouldn't have a problem selling targeted number of homes and memberships over the next 7 to 8 years. This is a quick overview on job creation, 300 plus jobs so far, total jobs about 4,400, and construction is well underway. Okay, now we'll shift gears and chat quickly for 5 minutes about our Saltaire project, and then we'll open it up for questions. So this is a second project that we have available. It's one we've been working on for several years with Coulter. It's an $800,000 project. This one is not in a rural area. It's a high unemployment TEA that qualifies, so the investment amount's $800,000. This is a luxury condominium tower being developed in St. Petersburg, Florida. Vertical construction's been completed. Final construction will be completed in about 13, 14 months from today. Again, secured EB5 loan investment. EB5's right around 20%. There's a loan repayment guarantee from Coulter's parent holding company, 526 approval refund guarantee. This project has 100% of the condos already sold out. This is one of Coulter's most successful development projects ever in the history of the company. Construction prices were fixed in 2019 with a gross maximum price contract, and increases in real estate prices in South Florida have resulted in significantly more profit being generated by this project than expected. All the jobs have already been created. There's $100 million plus senior loan already in place with Wells Fargo. And for those of you who don't know, Coulter is one of the largest developers in the southeastern United States, $19 billion of development over 25 years. They're one of the few developers that we've ever encountered that can say that not a single one of their projects has not been completed. There is no half-built Coulter project anywhere, and every single loan they've taken out has been repaid over 25 years, which is extremely rare. This is a recent construction photo from August. You can see the building going up there. It's directly overlooking a marina and a baseball field. Ron, I know you're a big baseball fan, so we'll see if we can get you in there for a deal. And
if you invite me, I'll show up.
Yeah. And as I mentioned, it's 100% sold out. All the buyers have put down 30% non-refundable cash deposits. They've taken over $80 million in non-refundable deposits to date on the project. This is another view from one of the units facing the ocean. And interior floor-to-ceiling glass, very, very attractive. Coulter's done 3 projects in St. Petersburg. This is the second. Third one is now just starting construction as well. Again, direct, unobstructed views. And job creation, significantly more jobs than are required for every investor, and construction so far advanced that we already have all the jobs for every investor. And again, going back to the immigration and financial safety, this is the key when you're evaluating any project. Where's the capital coming from? Is it all in place? How many jobs per investor? Is it underway? And then on the financial side, is it a secured loan investment? Does it have a repayment guarantee? Is there a approval guarantee? And transparent, ongoing financial reporting with an independent third party is really critical. Okay, we flew through that. We've got 10 minutes or so for Ron to take a few questions. So let's see. We've got a ton of questions. So let me just try to quickly summarize a couple of them here. Okay, here's one. Is it safe for a family to immediately file I-526E without a 956F receipt notice for a family with an age-out issue?
No, it's not, unless, so first thing is we have to get the settlement agreement signed. I hope it'll happen today, but let's assume it's signed. Then it is only safe to file the 526E if you have a receipt notice or a lockbox notice, or if 10 days have passed since the regional center actually filed the I-956F application. If you file before that, it could be rejected.
Got it. Or if you already have a receipt in hand, then you're good. But otherwise, you've got to wait 10 days.
Regional center already has a receipt notice, then that's great. Then you're good to go.
Perfect. Okay. So one question we got, the 956F is very similar to the 956, right? So, was there any, this is more around the settlement, was there any thought around some kind of combination of those forms, or was that kind of not really on the table, even though they're very, very similar?
Yeah, so to be honest, you have an I-956F that has a lot of the same information as the I-956, that has a lot of the same information as the annual statement that also has to be filed by December 29th. And the Immigration Service wants 3 different $18,000 fees to get a lot of the same information 3 different times. Do I think that's perfect? No. Is that a necessary part of getting this case settled? Yes.
Got it. One question. So if I'm an investor considering making a new investment, and I'm born in China, and I make an investment in a high unemployment project like Saltaire, am I for sure facing a 15-year wait, or am I now just going to be, facing some potentially smaller delay depending on how many people file under that 10% category, in the very short near future?
Yeah, I can only tell you what my opinion is on this, and the State Department that has to determine this has been less than completely clear. In my opinion, if you invest in a high unemployment project that is covered, that's within the set aside, and that is within the new TEA rules, you should be in a separate set aside quota category and not part of the 15-year wait. I think that the State Department agrees with that, but I'd love to see that be made more clear by the State Department. That is my view. I think you should be okay.
Got it. And another kind of similar related question, the 7% per country cap, does that separately apply to the set-asides, or how does that fit in, if we know anything at all about, how that could be interpreted?
We have had also, and, it's a question I have, not an answer I have. And We really need to see. I don't want to speculate how the State Department is going to come out on that. To me, it's an important question that's out there that's unresolved.
Got it. Okay, so that's a placeholder for now. In terms of the timing of these fees, what's your thought on, you know, when the $10,000 fee is going to start? Is that going into effect this year, or only applicable if you do file 956, or?
Yeah, I think it'll be in effect this year. I don't have definitive information on that. I mean, the Immigration Service is significantly short on staff. They need the income that's going to come in from the EB-5 program. And I think they will try to get as much of it as they can as soon as they can. So I expect that'll be this year, but I don't have definitive information.
Got it. Okay. Here's another question. So if I'm a family, husband, wife, and we have a 10-year-old child in the U.S., we're on H-1B, we invest tomorrow, we file 485, we adjust status, concurrent filing. Can the child go to school, public school, immediately after filing, or do we have to wait until we get EAD, et cetera?
The child can go to school immediately. Well, first of all, if you're an H-1B and you file for adjustment, the filing for the adjustment does not get rid of your H-1B. If the child was an H-4 when he filed for adjustment, he can continue on as an H-4 after he files for adjustment. But despite that, even if for some reason the H-1B or the H-4 expired, there's nothing wrong if the child does go to school while the adjustment application is pending. The EAD has nothing to do with the ability of the child to go to school. It only has something to do with the ability of the parents to work.
Got it. And how does that EAD versus the travel authorization, those two documents would be filed concurrently with the 526E, but how, in terms of approval timeline, are you seeing, you know, major differences between those two separate requests being approved? Are they usually approved together, or we have seen some EADs shorter?
I'm sorry, go ahead, finish up, Sam. I'm sorry.
We have seen EADs coming in 5 to 6 months, but I haven't heard much about the travel card approvals.
Right. So originally they were coupled together and done at the same time. There's been litigation that has kind of forced the government's hand in terms of moving quicker on EADs. And what we're seeing now is that generally EADs are granted quicker than advanced parole travel documents. They're both, in my opinion, way too slow. But I think we're starting to see most EADs in 6 months or less, whereas a lot of advanced paroles are 6 to 9 months or more.
Got it. Okay. And how under these new rules, you know, that are now in effect, how does it look for project developers looking to, you know, get a project in market, right? They can either file Form 956, start from scratch. How long do you think that'll take? Or, you know, the rental option is still available, but now, you know, a lot of regional centers are probably going to be, you know, going out of business or not wanting to rent due to the liability, or, you know, it's going to be more complicated, you know, to get a rental arrangement in place. What are you kind of seeing on that front of, you know, new projects coming together to go to market?
Yeah, so we actually do a lot of advising on this with new project developers and regional centers, and you have a few different choices. One is you can file for a new regional center. The problem with that is we don't know. There's been no adjudication of a 956 yet, so we don't know how long it's going to take. Probably in the short term, it'll take shorter. By December 29th, when they get hundreds and hundreds and hundreds of 956s, it'll probably take a lot longer. So I expect that it will not be quick to get a new regional center approved. If I had to guess, it'll be a year or more, but that's just a guess. So that's one option you have. If you choose that option, you can't proceed with your project, and you can't proceed with filing a 956F until the regional center is approved. Option two, you can hook up with an existing regional center and have work out an arrangement where the existing regional center agrees to sponsor your project, what you called renting a regional center. And that's fine. That existed under the old law. It still exists under the new law. It may happen less under the new law because the, quote, rental regional center has a lot more responsibilities, but it's still an option. The third option that you have is to buy an existing regional center. So I expect that there will be a significant number of the regional centers that were previously approved that will opt not to continue to do business because of the increased responsibilities, will opt not to do business under the RIA and therefore won't file. Well, if they're not going to file and continue to do business, they may say, you know, we have an asset here that we can sell, and maybe somebody else will want to buy a regional center and then continue it under the RIA. So buying a regional center is a third option. And we discuss all three options with our developer clients, and in each case decide what's best for them.
Got it. Okay, so one follow-up on the question earlier about the family on H-1B. Let's assume the family comes in on B-2. Then after 100 days, they file I-526. Can the child in that situation still attend public school after filing, or no?
Yeah, they should be. The answer is yes, they should be able to attend public school. We have a lot of those cases. We do a lot of E2s and E2s that convert to EB5s. And yes, the children can continue to go to school. They're not somehow violating their status if they do that. The key thing for E2s, unlike H-1Bs, is the E2s, the minute they file for adjustment of status, cannot leave the country until they get a travel document. So, you know, right. If they don't file for adjustment of status, they can continue to travel in and out of the country as much as they want on their E2 visa. If they do file for adjustment of status, they can't travel for maybe 9 months until they get the travel document. And that's something that is very important that our E2 clients understand.
Got it. Okay, so we've got time. One more question, Ron. So I was just in Vancouver. We were just doing an event in Toronto. In the last 6 months, we've seen a lot of interest from Canadian clients, and I'm sure you have as well. So one question and I've heard different opinions on this from different attorneys, so I want to get your thoughts. If I'm a Canadian investor, I'm in Canada, I don't have any unique, pre-applied for visa in the US, but I'm interested in EB5. So I come down, I go to Miami, I'm in Miami for 4 or 5 months. I can stay legally for up to 6, right? Because I'm from Canada. I'm there in month 5. I decide I love Miami. I don't want to move. I don't want to leave ever again. And I file my 526. Can I, adjust status and remain in the U.S. until I get approved, right?
Yeah,
and I don't have any special separate thing.
Yeah, the answer is yes, you can, but it's your burden. So in order to apply for adjustment of status, you have to be what's called inspected and admitted. And when you have a visa stamp, when you have a stamp at the airport, that proves you were inspected and admitted. When you're a border crosser from Canada, you have no stamp to prove you were inspected or admitted. How does anyone know if you might have just snuck across the border and nobody even knew you came here, in which case you're not eligible for adjustment? So when we do our Canadians as concurrent adjustments, we have the burden of proving that they really were inspected and admitted. And so what we're going to do is work with our clients to get a sworn statement saying, I came through Pearson, through the Peace Bridge port of entry. I came on this particular day at 6:15 p.m. I remember that I was inspected by this. It was a female officer who was, seemed to be in her 50s, and asked me these questions, and I gave these answers. And she said, fine, welcome to the US. I mean, as much detail as I can give to meet my burden of proof that I was inspected or admitted. So the short answer, Sam, is yes, it's possible, but it's more complicated than people who come in with a visa.
And when you do come in that way, you've got to remain for some period of time. before you do the application. You couldn't just drive across on Monday and file Tuesday, right? What do you kind of recommend is kind of the minimum period for that?
Yeah. So what we're talking about, if I come to the U.S. on a visitor's visa, and I come in on Monday, and basically, if I'm coming as a visitor's visa, either I'm stating at the airport, or it's assumed I'm coming to visit the United States. If I'm not coming to visit the United States, I'm lying. Well, if I come in Monday and Wednesday I file for a green card, it's pretty clear that maybe I wasn't telling the truth when I said I'm just coming to visit the United States. So we always suggest a period of time, and 90 days is usually a good number, that you wait after you come to the U.S. before you do anything relating to applying for a green card, which gets rid of the presumption that you lied when you came in and said you were visiting.
Got it. Okay, that makes sense. Ron, I know you got another appointment in a minute or two, but thank you very, very much for making yourself available to talk about the settlement and paint the picture for investors from around the world. We had several hundred people join us today who are considering exploring an EB-5 investment, and what things they are kind of more covered against now, and what risks still remain, and how to mitigate those. So yeah, I've left contact information on the slide here. Any immigration related questions about setting up a project or working on a new EB-5 application, source of funds, all those questions, please direct those to Ron. His contact information is there at the bottom. And any questions about making an EB-5 investment in either of the projects we talked about today, the Walhalla Utah rural project with partial investment ability, or the Saltaire St. Petersburg project by Coulter in South Florida, please reach out to me, info@eb5an.com, or in the chat box, sam.silverman@eb5an.com. And I'll also put the number here for WhatsApp as well. Go ahead, Ron.
Yeah, last thing I want to mention is for anyone who wants more information about the litigation and the settlement, we're posting a client alert in more detail on this on our website, classicolaw.com. And tomorrow we'll be recording a podcast just on this new settlement and the litigation. And hopefully the podcast will be up on our website next week. And lastly, thank you very much for inviting me.
Yes, absolutely. And when that settlement does get finalized and approved by the court, which we expect to happen, imminently, we'll send an article, we'll send an email, on that, just letting everybody know that the 10-day filing proof of submission rule is now in effect. So perfect. Thank you, Ron. We appreciate it. And if anyone wants a copy of the slides, just shoot a note, and we'll be happy to share the slides too. And you'll get a video recording if you want to review any part of the webinar again. All right. Bye, everyone. Thanks, Ron.
Bye-bye.